All Green Electric versus Security National Insurance Company. Now, I chose the slides, the pictures, and this has only sort of a tenuous relationship to the actual facts of the case. All Green Electric built an X-ray room for a doctor, and it didn't work because it turned out there was a loose bolt that was creating a magnetic field that wouldn't let the X-ray machine work. And so the doctor sued All Green. All Green tendered the claim on their CGL policy to Security National Insurance, and Security National Insurance denied the claim, and All Green sued. And the case revolved around the impaired property exclusion. So what that means is that if the insured's negligence causes an injury to the product or property of a customer, they're not covered for that injury if the property can be restored to if it can be fixed, in essence. So, for example, in this case, All Green was able to tighten that bolt, and the X-ray machine worked just fine. So the only way that All Green could have gotten coverage out of that would have been to establish that the injury had happened as a result of a sudden or accidental physical injury. So you'll see here, applying the impaired property exclusion to the facts here, the malfunctioning facility was the impaired property because the reason that it didn't work was that All Green didn't tighten the bolt or maybe didn't meet the standard of care. But tightening the bolt allowed it to be restored to the use. So there's a sudden and accidental exception to the exclusion. So if the loss of the use of the other property is due to a sudden or accidental physical injury to the insured's work after the insured is finished doing its work, then that exclusion doesn't apply. But one of the things that's kind of interesting about this case, because it's really a fairly standard application of the impaired property exclusion, and the facts are almost a perfect example of how the impaired property exclusion works, because it's a work that was done to build this. There
was no physical injury.
And no physical injury, exactly.
It just didn't work.
It just didn't work, exactly. But what's interesting is that when the All Green tendered to its carrier, of course, they said, there's no problem with our work. We did everything right. And by saying that, excuse me, they sort of talked themselves out of coverage, because then it became very difficult for them to make the argument that they had done something wrong, because they were on record as saying, no, we did everything right. And so there would have to be some kind of a miraculous thing where they installed it properly, but then in something they did later, damaged it in some way, and the court just wasn't buying it. And part of the reason the court wasn't buying it was that All Green had defended itself. So there are these cases where the insured says just exactly what you would expect an insured to say. There's nothing wrong with my work, but we do good work. And in saying that, they end up talking themselves out of coverage. And this is an example of that. I mean, it's a little unfair, I thought, but that's how it worked for them.
You don't really see this exclusion that much. I mean, there's this case and I think one other that applies it. But it demonstrates, number one, it was a win by the insurance company, and they didn't have a lot of wins last year. And number two, that you really look and see why that exclusion is there. Well, what is that exclusion supposed to accomplish? And it's supposed to be not be an effect of something that's physically damaged, which, Mike's pointed out there was nothing there. It was strange that everything revolved around tightening the bolt, though. Yeah, very, very tough battle for one issue.
Yeah, I must admit, I'm not as sanguine about the underlying purpose of the impaired property exclusion as you seem to be, Rex. I
That's
don't.
because you represent policyholders.
I'm just not sure what is the rationale? You tell me.
You know, that there's no physical damage and something's not working because the component's not working because the policyholder didn't do something properly, but it didn't cause any damage. That's why you see very few cases about the impaired property exclusion, okay?
Because you need to have some sort of property damage and just the
Usually you have
ability
some
to
sort
work
of
properly.
damage, okay?
Okay,
Yeah.
all right.
Not just it doesn't work, you have to have damage.
It's a loss caused by a negligent act of the insured, but because there's not property damage or bodily injury, the coverage, the policy
That's more or
will kick
less
in.
the point.
All right.
And it doesn't happen that much, so, don't worry about it too much.
Okay, the next case is also mine, Jones versus IDS Property Casualty.
Now, who's that?
That is Prince Philip, 93 years old, recently gave up his driver's license. It, again, doesn't have a whole lot to do with this case, which if I had Steve's discretion, I might not have used a funny photo, because the Jones case is about a car wreck in which Mrs. Jones' husband was very seriously injured, and she made a claim for loss of consortium. The question was her claim for loss of consortium subject to the same per occurrence limit as her husband's claim for bodily injury, or was it a separate occurrence entitled to separate coverage? I can't remember what the limits were. I think it might have been 300,000 per occurrence and $1 million aggregate. So the question that she had was, and her husband's, the award to her husband was way over the per occurrence limit of the policy. So in order for her to recover anything, at least through insurance, through the negligent driver's insurance, she would need to have, she would need for it to be a separate occurrence. The law has long been, really, I mean, the weight of the cases, the Jones court went through 5 cases, maybe 6 cases, and of those, only one of them had found that the loss of consortium claim was not subject to the same occurrence limit. So it was pretty clear, and what it boils down to is the language of the policy. And once the cases started coming down, of course, the carriers all started writing their policies so that they came in under the same occurrence. So the policy in Jones was the maximum we will pay as damages for bodily injury, including damages for care and loss of services, to one person per occurrence. So care and loss of services, of course, is a loss of consortium claim. That's what you're suing for when you are not physically injured. You're suing for the loss of care and services from your spouse. And it also said that the bodily injury liability limit for each occurrence is the maximum we'll pay, including damages for loss and care of services, to 2 or more persons in any one occurrence. No more than these maximums, regardless of the number of vehicles, insured persons, claims, claimants, policies, or vehicles involved in the occurrence. So it was pretty clear. And it had been written, as I say, on the strength of this run of cases that defined how you could subject a loss of consortium claim to the same occurrence limit. And obviously, loss of consortium is a separate claim, and that's what Jones argued. But really, they published Jones, and so it made law, but it's consistent with the run of cases, certainly for the last 20 years, on that issue. So, just so you know, the rule of Jones reminds you that loss of consortium is going to be subject to the same, is going to be considered the same per occurrence, subject to the same per occurrence limit as the bodily injury claim of the injured spouse.